Hi guys, welcome back to my channel. Thank you so much for clicking this video. And I wanted to share with you guys, I want to hear what you have to say, what your guys' opinion is, and I want to share some stuff with you. So for the last few days, I have been going back and forth. Like, it's been troubling me. Like, I am so interested in the critical K, the case that's came upon her. Like, what is the line of freedom of speech and defamation or a lawsuit? Like, where is that line? Because believe it or not, this could be huge. This could have huge consequences on all creators. I've listened to some of what you guys have to say, and I agree with you guys a lot. I hear, other people are saying, well, you have nothing to worry about, or other, commentary channels, they don't have nothing to worry about because they're not nasty like Kay. Like, Kay goes really nasty when she talks about stuff, and I understand that. But also, I think when you start putting something in motion, it can have a ripple effect, so I don't know. But I went in and found some information, and I want to share it with you guys, and I want to see what you guys think. But in doing so, I want us to, just for this video, not think about how we emotionally feel about Kay, okay? So you might not like Kay. You might think Kay's a nasty person, a vile person. You might think she's done some really nasty stuff, okay? I'm not going to sit here and say I disagree with you. But I want us to just think about this as unbiased as we can. Let's think about this from a place where, let's just say, for the sake of this video, we like Kay, let's not put our emotions in it when we think about this, okay? That's just where I'm standing when I've been digging for this information. So my first thought is, and somebody mentioned to me on my last video, and they said, where's the line drawn and all that? They said, the autopsy report, pretty much point blank period right there. Sharing the autopsy report and all that. I didn't really get to go in and look at all that information. I did just print out this huge thing to go through and look at. I would love to hear somebody who is in law or somebody who's studying law to hear what your opinion is. So from what I briefly read on autopsy reports, it goes by state, the different laws. Now here's what I don't know when it comes to this. I don't know if, say, the autopsy report has already been shared, if that information is already out there, do these laws apply? And also, I don't know if, does it go by the state that the death was in? Or let's say, say you live in Detroit, but the crime was actually in New York. Do you go by the laws that are in New York or in the laws that were Detroit? I'm not really sure about that. Some people, they think that, like, true crime communities shouldn't exist at all. They feel like that's just invasion of, privacy. And I understand that. I really do. My opinion on it is it's really no different than like a documentary or a news reporter or somebody who's making a movie on it. As long as I feel like it's handled with care. And I think, to me, that's kind of where the line is drawn. So, for instance, the story I have been working on, I have to state the facts. The facts are out there, and they're not all that pretty. And, when it comes to the victim, the facts are not all pretty when it comes to, talking about it. But I also, and this is kind of why it's been taking me so long to get this story out there, is because I do want to make sure I do portray this story as delicate as I can, because even though the facts might not be all that pretty, this person still deserves to be honored with respect. So I do want to make sure that when I do, my story, I am putting out, he was, goofy, but he loved to make everybody smile, and he was, he had a lot going for him, and he, loved baseball, and you just really kind of put who he really was as a person, but then you can also state your facts. And I think maybe that's where the line is, and I feel like maybe that's where Kay kind of drops the ball. And to her defense on that, I'm wondering if it's because sometimes I feel like when you get so engrossed into a case and you've been, reading into it and reading all these different information about it, and you've been going for weeks and weeks, looking at all this stuff, I feel like it kind of starts to become almost like a puzzle per se. It's like you're just putting the pieces together, and it's like you've emotionally have stepped back. And I kind of feel like maybe that's where like cops and detectives are, that they have to like emotionally put themselves out of it to be able to unbiasedly read the scene. And sometimes that I feel like you forget that you're talking about real people. You're talking about, people who've lost somebody, family members who are grieving. I think all that kind of gets forgotten, and it's like you're too deep into it and you got to step back and like, okay, wait a minute, maybe that's what's going on. I'm not really sure. But so I'm very curious of where this case is going to go, what the outcome is going to be. So I started looking up the libel and the slander. And defamation is a tort that encompasses false statements of fact that harms another's reputation. So here's another thing that I'm kind of a little iffy about this case. Okay. Is Kay's, when she was talking about this case and when she was presenting the information about this case, was she doing it in a malice way? Or did Kay honestly believe the things that she was saying? I know she keeps saying, like, if this was your son or your daughter, you would want somebody like me to step in and to, fight for them. Okay, my first reaction is, Kay, you're not a damn lawyer. Sit down. But then I'm like, okay, well, his mother was kind of accusing, making accusations against, Whitley and Dylan, pretty strong accusations that could really be harmful to them. So that to me could probably be a case right there. It's almost like she was kind of doing the same thing to them as Kay's doing to her. So is there two different cases that could be brought? I don't know. My opinion on this case is my personal opinion. I don't blame, Ray. I'm telling you right now, if that was one of my children, I would do the same thing. I cannot say I wouldn't do what she was doing. I don't blame her at all. She's a grieving mother. My personal opinion on this case is I do feel like there was enough probable cause to bring this in front of a court, in front of a jury. There were some experts that had came up and said that there were some questionable things. I feel like everything should have been brought out on the table. Things should have been, explained. Now, would that have, put things to rest? Would that kind of ease her mind a little bit? I think so. I may be wrong, but I think so. To me, I feel like since this case didn't become of anything, that it's almost like it became vigilante justice. And I think that's sad that her and her family had to take that into their hands. That's just my personal opinion on the case. Okay, so let's go on to what I read about. So, right to protect one's good name is the heart of a defamation law. Defamatory comments might include false comment that a person committed a particular crime or engaged in certain sexual activities. Defamation suits can have chilling effects on free speech. However, defamation suits can threaten and test the vitality of First Amendment rights. If a person fears that she can be sued for defamation for publishing or uttering a statement, he or she may avoid uttering that expression, even if such speech should be protected under the First Amendment. Now, I know you're probably thinking, okay, what's wrong with that? What I'm worried about with that is if people start feeling like they can't express themselves, whether or not it's awful or not, they might start doing it more sneakier, then groups are formed, and it could just be nasty. It could just be a bad thing. I think it would be better if people were able just to express themselves, and then, again, you're free to express yourself, but you're not free from the consequences. So if somebody else puts all that information out on blast and it hurts your employment and all that, then that happens, but, Okay, New York Times Co. versus Sullivan changed libel law nationally. Until the later half of the 20th century, the law seemed to favor those suing for reputational harm. For most of the 20th century, a defendant could be civilly liable for defamation for publishing a defamatory statement about or of concerning the plaintiff. A defamation defendant could be liable even if he or she expressed defamatory comment as opinions. In many states, the statement was presumed false and the defendant had the burden of proving the truth of his or her statement. In a sense, defamation was closer to the concept of strict liability than it was negligence or fault. This means that public officials suing for libel must prove by clear and convincing evidence that the speaker made the false statement with actual malice, defined as knowledge that it was false or with reckless disregard of whether it was false or not. And that's where I'm wondering if that's going to be the problem. Because did Kay say what she said out of malice? Was it to harm the other, who she was talking about? Or did she generally feel those feelings? Like, does she actually believe that? I don't know. Let me know. Is that, I thought that was interesting. I don't know. Okay. Courts create different standards for private figures. And this is something else that I'm kind of iffy. I don't know about. The Supreme Court clarified the limit of actual malice standard and the difference between public and private figures in defamation cases in Gertz versus Robert Welch, Inc., 1974. The case involved a Chicago lawyer named Elmer Gertz who represented the family of a young man killed by police officer Richard Nuccio. Gertz took no part in Nuccio's criminal case in which the officer was found guilty of second-degree murder. Robert Welch, Inc. published a monthly magazine, American Opinion, which served as an outlet for the views of the conservative John Birch Society. The magazine warned of nationwide conspiracy of communists. Sympathizers to frame police officers. The magazine contained an article saying that Gertz had helped frame Nuccio. The article said Gertz was a communist. The article contained several factual misstatements. Gertz did not participate in any form to frame Nuccio. Rather, he was not involved in the criminal case, and he was not a communist. Gertz sued for defamation. The court had to determine what standard to apply for private persons and the so-called limited purpose public figures. Then the court had to determine whether Elmer Gertz was a private person or some sort of public figure. Magazine argues that statements related to public concern should have higher libel protections. And so that's my question. Is Kay considered a public figure or private? So the court sided with Gertz on this question and found a difference between public figures and private persons. The court noted two differences. Public officials and public figures have greater access to the media in order to counter defamatory statements, and two, public officials and public figures to a certain extent seek out public acclaim and assume the risk of greater public scrutiny. This standard means that a private person does not have to show that a defendant acted with actual malice in order to prevail in a defamation suit. The private plaintiff usually must show simply that the defendant was negligent or at fault. However, the High Court also ruled that private defamation plaintiffs could not recover punitive damage unless they showed evidence of actual malice. In its opinion, the court also determined that certain persons could be classified as limited purpose public figures with respect to a certain controversy. The court noted that full-fledged public figures achieve persuasive fame of notoriety. However, the court noted that sometimes an individual injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. Importantly, these limited purpose public figures also have to meet the actual malice standard. If the plaintiff is merely a most important issue in defamation case is determining the status of plaintiff. These cases show that perhaps the most important legal issue in a defamation case is determining the status of the plaintiff. If the plaintiff is a public official, public figure, or limited purpose public figure, the plaintiff must establish that the defendant acted with actual malice with clear and convincing evidence. However, as Judge Robert Sack wrote in the Treatise of Defamation Law, determining who is a public figure raises more important questions. If the plaintiff is merely a private person, the plaintiff must usually only show the defendant acted negligently. If the private person wants to recover punitive damage, he or she must show evidence of actual malice. So the basic requirements of a defamation case is 1. The plaintiff must show that the publication was of and concerning himself or herself. 2. Publication. The plaintiff must show that the defamatory statements were disseminated to a third party. In slander cases, this generally means that the speaker defamatory comments must be heard by a third party. Defamatory meaning. The plaintiff must establish that the statement in questions were defamatory. For example, the language must do more than simply annoy a person or hurt a person's feelings. But one court reasoned that calling an attorney an ambulance chaser does have defamatory meaning because it essentially is accusing the lawyer of violating the rules of professional conduct, which limit solicitation. Falsity. The statement must be false. Truth is a defense to a defamation claim. Generally, the plaintiff bears the burden of proof establishing falsity. Okay. Statement of fact. The statement in question must be objectively verifiable as false statements of fact. In other words, the statement must be provable as false. Damages. The false and defamatory statements must cause actual injury or special damages. Defense and privilege in a defamation case. So these are like some things that are kind of like would kind of be like the loophole through it. These are a few things I'm kind of like, I don't know if she falls in these or not. So the libel-proof plaintiff. This defense holds that some plaintiffs have such a lousy reputation that essentially they are libel-proof. The theory is that one cannot harm someone's reputation when that person already has damaged reputation. For example, those with extensive criminal records could be considered libel-proof. I'm not saying she has like a lousy reputation. I didn't mean that. But has this been already said? Has others felt this way? Or was this like the first time, whatever case said, was this the first time everybody's hearing this? Or was these things kind of already out there against her? I don't know. Rhetorical hyperbole. Rhetorical hyperbole is a First Amendment-based defense that sometimes can provide protection for a defamation defendant who engages in exaggerated and hyperbolic expression. For example, the U.S. Supreme Court once ruled in Letter Carriers versus Austin, 1974, that a union's use of the word scab was a form of rhetoric hyperbole. Some courts will hold that certain language in certain contexts, editorial/opinion columns, is understood by readers to be figurative language, not to be interpreted literally. Retraction statutes. Nearly every state possesses a retraction statute that allows a defamation defendant to retract or take back a libelous publication. Some of these statutes bar recovery, while others prevent the plaintiff from recovering a so-called punitive damage if the defendant properly complies with this statute. So if Kay comes back online and retracts everything. Defamation, like many other torts, varies from state to state. For example, states recognize different privileges and apply different standards with respect to private person plaintiffs. Interested in parties or practitioners must carefully check the case laws of the respectable state. Defamation suits can further important interest of those who have been victimized by malicious falsehoods. However, defamation suits can also threaten First Amendment values by chilling the free flow of information. Once again, this is why many states have responded to the threat of meritless defamation suits by passing so-called anti-SLAPP statutes. This was all written by David L. Hudson Jr., is a First Amendment fellow at the Freedom Forum Institution and law professor at Belmont who published widely on First Amendment topics. He is the author of a 12-lecture audio course on the First Amendment entitled Freedom of Speech. So that's who wrote this article. I thought it was very interesting. But I want to hear what you guys think unbiasedly, not putting your emotions in how you feel about Kay. Your honest opinion. Do you feel like there is a case here? Let me know in the comments below. If you haven't already, give this page a like. Always leave me a comment. And if you haven't yet, subscribe. I will see you guys really soon. I'm going to keep looking and seeing what else I can find. If you guys want me to check anything out, please let me know below. I will see you guys really soon. Take care.